Okay, so yesterday we dealt with chapter 1, which was basically the constitution in a South African context. And that was an introductory tutorial just to give you an understanding about what constitutional law is about, what is a constitution. Godfrey has indicated that the link for that tutorial will be provided to you once they are done with editing, so just keep a lookout for that in case you need to refer back to it or in case you missed it. And today what we are going to be dealing with is chapter 2. So it's the basic concept of constitutional law. And just a reminder again, colleagues, yesterday I referred to it as a study guide. I hope that didn't cause any confusion to any of you. But the diagram on page 6 of your tutorial letter 102, there's a diagram there that Professor Stone has prepared. Very important, a very nice summary of constitutional law and all the topics that are going to be covered, a nice summary of basically the textbook, the different chapters in the textbook. As you know, we are only going to be dealing with chapters 1 to 8 and some of the content in chapter 9. So if you have regard to that diagram, it is really helpful just to give you an overview or an oversight of what the module is about, what is going to be covered, and even when you're studying and you just want to check that you've covered all your material or just for reference purposes, that diagram will be very helpful to you. So I'm going to keep emphasizing it in every tutorial that that diagram is very, very important just to aid your understanding, and Professor Stone refers to it quite a lot. So just ensure that you have had a look at it in your preparations. Okay, so the content that is going to be covered today is from pages 28 to 50 of the study guide. Again, I'm referring to study guide, but actually I'm referencing your tutorial letter. So if I do mention study guide, that is what I am referring to. And what chapter 2 basically deals with, colleagues, are the crucial concepts that one needs to understand in order to effectively understand South African constitutional law and how the constitution operates. So these concepts are necessary for this module, but also just for your general understanding in terms of the constitution, what the constitution is about, why we have a constitution. So it is important to have a thorough understanding of these concepts in order for you to apply them, whether in your exams, whether in your assignments, or even just legal practice. If some of you go on to actually practice in constitutional law or deal with constitutional law matters, these are pillars or these are concepts that you will need to understand for those purposes. Okay, so these are the 4 concepts that we are going to be dealing with and which are covered in chapter 2. Constitutionalism, separation of powers, the rule of law, and democracy. Okay, so jumping straight into constitutionalism, how we can define constitutionalism is that it's the idea of a political community in which elected politicians, government officials, and judicial officers act under the authority of a written constitution, because legitimacy and power is derived from the constitution itself, and the constitution places limitations on the exercise of these powers. So to simplify this, what it essentially means is that in the government of a specific country, the government officials there in all the branches of government basically defer to the constitution to give them powers, to give them authority to do whatever they need to do. They are basically subject to a constitution. They do not just act of their own volition, or they cannot just exercise authority generally. They do have to subject themselves to a constitution, and it's usually written. Not every country has a written constitution, some do not. But generally, when we talk about constitutionalism, it's basically an idea that your government officials are subjecting themselves to the authority. I mean, well, the authority is subjected to a constitution which regulates how they can exercise their authority. And then just looking at the purpose of constitutionalism, we can say that the purpose of constitutionalism is to establish a government legitimately empowered to realize the political community's best interests, to structure government into a unitary or federal state, to impose binding, clear, and ambiguous rules to control the exercise of power to prevent oppression and abuse of power. So in terms of a unitary or federal state, what we mean by that, I did touch on it yesterday, is that a unitary state is one that simply has one national government. You don't have different levels of government like South Africa would have. It's essentially one government which exercises authority over the entire country. We in South Africa have a federal state to an extent because we've got different spheres of government being local, provincial, and national. So the power or the authority is broken up in that way. And then when we talk about oppression and abuse of power, as we know, during apartheid, which informed the drafting of this constitution, there was oppression, there was an abuse of power, power was used to discriminate, it was used to oppress. So when we look at constitutionalism, we look at imposing binding and clear rules that ensure that the people or the inhabitants of the country cannot be oppressed, or they shouldn't be oppressed. So part of the purpose of constitutionalism is to ensure that the subjects of a country are actually protected and they are not subjected to oppression, or power is not abused. Okay, then jumping into characteristics of constitutionalism, it is concerned with formal and legal distribution of power within a given political community in which a government is established by a written constitution. So again, we see that emphasis on a written constitution, very important because you can refer to it. It's a living document that you can actually refer to determine government's power. So then coming to the second point, it provides for the establishment of institutions of governance comprising the legislature, the executive, and the judiciary that we also mentioned yesterday, and we're also going to elaborate further on that when we get to the separation of powers as a concept. Creates binding rules or laws for the regulation of the political community, its institutions of governance, and the governed. So I think I skipped there. When we talk about binding rules or laws, it means that these can actually be enforceable, and they should be enforceable to the subjects who they are governing. So when you've got rules or laws, they should actually be enforceable in order for them to actually uphold constitutionalism. It doesn't help to have rules or laws and you can actually not enforce them. Then that wouldn't assist, or that wouldn't uphold constitutionalism. Constitutionalism plays a role in determining the nature and basis of relations between institutions of governance and the governed. It prescribes the limits on the exercise of power and provides mechanisms to ensure not exceed limits set by the Constitution. So again, there we're seeing a very important feature of limiting power, because once power is not limited, then it is open to abuse, and it affects the subjects of the state or the country concerned. So the limitation of power is a very important feature or characteristic of constitutionalism, and deferring to the Constitution as a supreme law. Okay, and then the foundation of constitutionalism is found in the Constitution itself, obviously, and it has two main functions, which is to establish institutions and structures of governance and allocate power to them. So again, it doesn't just help creating, for example, a legislature or an executive or your judiciary, and they actually do not have power to do anything or to implement anything. There has to be allocated power, and this is done by virtue of the Constitution. And then another function is to limit and disperse that power amongst the institutions and structures to ensure it will not be abused. So again, that speaks to the principle of the separation of powers, where authority is distributed to the various branches of government in order for them to take responsibility for those and to exercise authority in terms of those. And then we see in S versus Makonyane, it was discussed that the precise manner in which a constitution is structured and interpreted is based on the political and social history of that community. Thus, constitutional systems are based on explicit norms and values. And again, this just speaks to the history of South Africa, what we were trying to do with this constitution to address injustices of the past. So constitutions are very unique to countries. That's why you'll see that with our constitution, even in the Bill of Rights, even how it's laid out, even the elections and those provisions related to that, it speaks to the history which South Africa suffered, and it aims to address that. And in S versus Makonyane, it was also elaborated upon that our constitution is different. It retains from the past only what is defensible and represents a decisive break from a ringing rejection of that part of the past which is disgracefully racist, authoritarian, insular, and repressive, and a vigorous identification and commitment to a democratic, caring, and aspirational egalitarian ethos expressly articulated in the Constitution. So this just further elaborates on the point that our Constitution is unique. It's unique to South Africa, it's unique to our challenges, and it's unique to the journey that we are on to ensure an equal society. Okay, so in terms of constitutionalism, we've got two types. And interestingly, South Africa has actually been on both ends of this. They've had a descriptive type of constitutionalism, and then we've also had what we currently have now, rather, a prescriptive type of constitutionalism. So a descriptive type of constitutionalism, or constitutionalism as a descriptive doctrine, provides a factual description of institutions, procedures, and structures that make up a constitutional system. It focuses on explaining the distribution of power between the branches of government, but it does not concern itself with whether state power is being used in contravention of democratic or human rights and norms. It does not make value judgments on whether the state adheres to its own constitutional limits. And we've got a form over substance here. So there's no looking at whether human rights are being violated. We're not making value judgments on what legislation is actually trying to achieve. It's just basically describing government and the functions of government and what government's power and limitations are. So descriptive constitutionalism basically represents South Africa before democracy. So during the apartheid era and all the times before that, that is what would describe constitutionalism as a descriptive doctrine. And then we go to the case of Harris and others versus Minister of Interior and another. This is a case that I did mention yesterday. It's the one where the Union Constitution basically required that constitutional amendments be passed by two houses of Parliament sitting together with a 2/3 majority. However, a constitutional amendment which was aimed at removing colored people from the voters' roll was passed bicamerally, meaning both houses of parliament sitting separately with a simple majority. And in this case, the court basically highlighted that the failure on the part of parliament to pass the constitutional amendment in accordance with the procedure set out in the Union Constitution resulted in legislation not being recognized as an act of parliament, and it was therefore invalid. So the court did not look further. The court basically said this didn't follow the particular procedure that it needed to follow, and therefore the conduct was invalid. And we see there that Parliament was basically, the courts were only empowered to determine on procedural grounds whether the amendment was valid or not. They didn't look at whether removing colored people from the voters' roll was constitutional or not, whether rights were being violated. They basically said this did not go according to procedure and therefore it is invalid. So you see a very strict or narrow interpretation of constitutionalism, where you just look at the rules, you interpret them, and you apply them as is. You don't make value judgments as to what is fair or not, what is discriminatory or not, what is violating human rights or not. It's just basically a strict application of the law. So that was South Africa pre-democracy. But what we have today, colleagues, is constitutionalism as a prescriptive doctrine. And what that essentially means is that it seeks to define in general terms the manner in which the state power is allocated and exercised, but it takes it a step further and it establishes norms and principles that define a constitutional government. It demands that constitutional systems must adhere with norms and principles such as the separation of powers, the rule of law, democratic self-government, the protection of human rights, and the existence of an independent judiciary, which is a very important feature, colleagues, of a constitutional government. If you don't have an independent judiciary, then you compromise justice, you compromise people's human rights, because the judiciary is then influenced by the other branches of government. It's influenced by, for example, the political party that is in office. It's just not independent. So we can describe this type of constitutionalism as substance over form. We don't just look at the rules, but we look at certain values and certain principles that would need to apply. And it represents South Africa in its current democratic dispensation. And there again, we go to the case of S versus Makonyane. I did read a bit from the previous slide, but yeah, essentially we look at norms and values, and we look at certain principles. We don't just apply the law as is, and the judiciary is independent. Okay. And then we move on to the characteristics of a constitutional government. So this is essentially how you would determine that the government of a specific state or country is one that is constitutional or led by the Constitution. And these are the characteristics that we can look at. Okay, I see there's a hand up. Josiah.
Yes.
A question or comment?
Can I ask a question, ma'am? My question
Sure.
is based on the State versus Makonyane case.
Yes.
I'm trying to connect how you connect it with constitutionalism. I'm not very clear how does it match there?
Okay. All right. If you know more about S versus Makonyane, you'll remember, Josiah, that it was one of the first cases heard after the new constitution was enacted.
That's correct.
Yes, and it basically dealt with the death penalty, but they drew a lot on the Constitution and its function and the new constitutional dispensation. So there was a lot of discussion. If you read the body of the judgment, that discussed the difference between the old South Africa while during the apartheid era and what they were trying to achieve with the constitution. So there was a lot of discussion about what the constitution is trying to achieve, who it's trying to protect, what laws we could take over from the apartheid era, which ones we couldn't. So that is where it basically links. So there were a lot of constitutional principles that were discussed in that judgment, aside from actually giving a judgment on the death sentence and whether it was constitutional or not. So that's the link there.
Okay, all right. No,
All right. I hope I've answered your question. Okay.
Correct. Yes, yes.
Sure. Okay, so going back to the characteristics, as I mentioned that.
Hi, ma'am. How does the case of the City of Tshwane municipality and AfriForum link to the constitutionalism?
Yeah, I have to go to that one. I don't think I included it in my slides of today. Would you like us to deal with it separately?
It's fine, ma'am. It's fine.
Okay. All right. But from what I recall from that case, when I read it a while back, it dealt with the change of the name. I think it was from Pretoria to Tshwane. And I think what they were basically discussing there was it was whether the public was entitled to participate or not. And it basically entrenched the principle of a participatory democracy, that people need to be involved in these procedures when, for example, things like name changes are taken. From what I recall from that case, that's what it was surrounding. So what you'll note that when we discuss further, the last point actually that we're going to be dealing with is democracy, and how there are different types of democracy, and how one of them is participatory democracy. So the constitution basically entrenches certain activities or certain conduct that the public needs to be able to participate in. And I think, yeah, that's where that case maybe would find application in the principle of democracy, and particularly participative or participatory democracy. But we will discuss that as a concept on its own, and then maybe we can go back to that case, because from what I recall, that is what it pertained to, basically just how the public can participate in certain actions that government takes. Okay, going back to the characteristics of a constitutional government, we talk about norms and values. So this links back to what we were saying about prescriptive constitutionalism, where you don't just have laws that prescribe what need to be done, or that describe rather what needs to be done, but you've actually got norms and values that you look into when carrying out specific public power. Then we've got the principle of constitutional supremacy that we discussed yesterday, where basically the constitution is the supreme law of the land, and all conduct and the law has to be in accordance with it, otherwise it will be invalid. We've got the separation of powers, which we're also going to discuss as a separate concept, where government has to be divided into specific branches, all of which exercise authority. Then we've got the rule of law, which we're also going to be discussing as a separate concept, and that essentially means everyone is equal before the law. No one is above the law. We've got democratic self-government, again speaks to the principle of democracy, and how the public or the inhabitants of a country should be able to participate in government. We've got the protection of human rights. We don't really deal with human rights in this module. It's dealt with, I'm advised, in a separate module. But you should always keep it in the back of your head that a big part of the Constitution is actually the upholding of human rights and the protection of human rights. Then we've got an independent judiciary with power to review law or conduct. Very, very, very important, colleagues, a very important feature of constitutionalism and having a constitutional government is having an independent judiciary. Because once the judiciary is influenced by any person, any institution, or any other branch of government, then that will be an injustice, because it won't be able to exercise its authority without fear of favor, and that would result in injustice. So having an independent judiciary is such an important feature in terms of a constitutional government, and in order to ensure that the government operates on a fair basis. And then we've got free, fair, and regular elections, also very important, because certain races were deprived of that during apartheid. So it's a very important feature of constitutionalism to have free, fair, and regular elections, as we do in South Africa. And then institutions established to uphold and protect the Constitution. And these are your various offices, like the Office of the Public Protector, which essentially are there to protect the rights of the public and look into conduct that is not upholding the Constitution or that is infringing on people's rights. And then we've got the devolution of power, which is again dividing power between individual whether branches of government or institutions, so that it is not open to abuse. So those are the characteristics, colleagues, and if you look at these characteristics, you will note that South Africa actually has all of these characteristics. We can see it in our constitution, we can see it in our laws, we can see it in how government is run, that South Africa is actually a constitutional state with a constitutional government, and it does actually uphold the principle of constitutionalism in a prescriptive sense. Okay, and then going to modules of constitutionalism. So this is just a summary. We did do a bit of the history yesterday in terms of the Westminster constitutional model. And this was essentially based on Britain's unwritten constitution. So very interesting that to date, they still have an unwritten constitution, but what you will find is that they've got, for example, an act that deals with human rights. They've got different acts also that include what we have in our constitution. So they don't have a constitution as a document, but the principles of the constitution are detailed in separate pieces of legislation. It's also in case law, but it's largely unwritten. They don't have one single document that they can term a constitution. So with the Westminster constitutional model, Parliament is of central importance and exercise sovereign law-making powers. So it's the principle that we spoke about yesterday of parliamentary sovereignty, and that is what is practiced in Britain. There's an absence of limitations on Parliament's law-making powers, but not an absence of all limitations on Parliament's actions. So Parliament essentially still has to respect the rule of law, that no one is above the law. So even though Parliament is the highest lawmaking power, there are still certain principles that they need to uphold. And then we go to the United States constitutional model. This is actually one of the longest surviving written constitutions. There's a strict separation of powers, which has checks and balances. The president can block legislation from being passed, which is a very interesting feature that they have. And the courts can declare legislation unconstitutional. So that is also a feature that we have in our constitution of constitutional supremacy, where the courts can declare conduct or laws invalid. And then we've got the German constitutional model. I also spoke about this a little bit yesterday. It's very similar to our constitution and our constitutional dispensation. It's based on the injustices of the past. It was very influential on the South African constitution. and it upholds the principle of constitutional supremacy. And they focus also a lot on a value-based democratic order, which attempts to secure democratic rule in Germany by binding the democratic process to the values and principles expressed in the constitution. So again, similar to us, prescriptive constitutionalism, there are certain values and principles that they apply with their constitution, alongside their constitution, which their constitution is based on. It's not just interpretation. And then they have, interestingly, what they call an inviolable human right, which is the right to human dignity, and that is also largely influenced by their history with the Jews and what they suffered. And then they've got the principle of Rechtsstaat. Pardon my pronunciation, I'm not German. And this feature basically means that the constitution is the highest law and that all laws must comply with it. And also that state actors must strive to protect freedom, justice, legal certainty, and we can also link this to the rule of law. It basically embodies the principles of the rule of law. And also they have a separation of powers. Okay, so an overview of constitutionalism in South Africa. I'm not going to go in depth with this because we did deal with it quite a bit yesterday. You can just refer back to yesterday's tutorial for an in-depth discussion on South Africa's history, from inception until now, and all the various stages that they went through. But in terms of constitutionalism, we had the constitution adopted by the Union of South Africa in 1910. There was no Bill of Rights. It was largely centered around parliamentary sovereignty. And then we've got the Republican Constitution. So this is the constitution that was adopted in 1961 after South Africa obtained independence from Britain. It wasn't very different from the 1910 constitution, except that obviously the British monarch was no longer the head of state. And then it also further entrenched parliamentary sovereignty. And then we go to the phase of the repugnant constitution between 1948 and 1994, where the National Party basically used parliamentary sovereignty to insulate many legal provisions which discriminated against Black people and restricted the rights of citizens. So this was done all the way up until 1983, when they attempted with that constitution that made provisions for Indians and colored people to participate in parliament, which didn't work very well, as I indicated yesterday. And then after that, we basically had the constitution, the interim constitution, and the final constitution. I'll deal with that on the next slide. So what we have here is the post-apartheid South African constitutional system, and that basically includes the interim constitution of 1993 and the current South African constitution of 1996. And it has transformative features, as I said yesterday. The constitution is a living document. It aims to basically change society, to improve society, so that we do not suffer the injustices of the past. So the features of a transformative constitution is constitutional supremacy, sovereignty, democracy, the rule of law, and entrenched constitution. And what is meant by entrenched is that it's actually binding. All the inhabitants of South Africa are bound by the constitution. Government itself is bound by the constitution. Justiciability of all rights in the constitution. That essentially means that in order to protect your rights, you can actually go to court, or you can go to the relevant adjudicative bodies to entrench your rights, or to protect your rights, or to enforce your rights. We've got values informing the constitution, and we've got a quasi-integrated cooperative federalism. And what is meant by that, I think I also touched on it yesterday, is the relationship between the different spheres of government. being local, provincial, and national. All of those work together and they cooperate with each other to actually uphold the Constitution and to serve the inhabitants of South Africa. Okay, moving on to the separation of powers now. Are there any questions on constitutionalism as a principle? So I'm going to move on to the separation of powers. Okay, so with the separation of powers, colleagues, we are going to deal with this as a topic on its own. It's got a tutorial of its own, so I'm not going to do an in-depth tutorial on it because it is coming up in chapter 3.
I would like to ask, you were talking about the concept, you're talking about the principles, and then features, and then this lot of things. You mentioned the very same thing on each and everything that you were saying about the features, the principles. So I don't know if it's the same thing or what. Maybe if you can explain on that.
Okay, so the slides to see what you're talking about, because one of it was constitutionalism itself. Then I talked about a constitutional government. Let me see. Yeah, so this was dealing with actually a constitutional government, not constitutionalism itself. So these are features that are attributable to a constitutional government that actually upholds constitutionalism. So in order to determine whether a government is a constitutional government or not, these are basically the characteristics that you would look at. Okay. All right. Are you fine?
Okay. Yeah.
Okay. Okay, so colleagues, as I mentioned, separation of powers, I'm not going to do an in-depth tutorial because we are going to cover it in chapter 3. Chapter 3 specifically addresses the separation of powers. So this is basically just an introduction, just so that when we mention the separation of powers, you can understand what we are talking about. So as a definition, the separation of powers is a doctrine which entails the institutional division of public power between 3 branches of government, namely the legislature, executive, and judiciary, to limit power. And the purpose of the separation of powers is to create a society in which abuse of power by government is curtailed and public power is exercised appropriately. It ensures predictability and transparency, and that power is not concentrated in one branch, person, or office. So when we look at this, essentially what the separation of powers is aiming to do is to limit power. So it divides the power that government has into 3 branches, so that no branch of government can basically exercise all the power, because then it would be open to abuse. So the very aim of the separation of powers is to avoid the abuse of power by government by splitting up that power and limiting it. Yeah, so here we say no provision of the Constitution makes reference to the separation of powers, but the arrangement of the Constitution conveys that there are 3 branches. And when we look at those specific sections, you'll see that we are talking about the different branches of government, the executive, the legislature, and the judiciary. So whilst the Constitution itself doesn't have the wording to actually say we've got a separation of powers, we can actually see by the arrangement of the Constitution that South Africa actually does embody the separation of powers, because we can see that authority is given, for example, to the legislature, authority is given to the executive, authority is given to the judiciary. So if you're looking for a section in the Constitution that is talking about separation of powers, you are not going to find it because it doesn't exist. But we can just infer from how the Constitution is arranged that there is actually a separation of powers. Okay, so in terms of the history of the separation of powers doctrine, colleagues, we find that it has its origins in the political philosophy of the Enlightenment in 17th century Europe. So that is where it is believed to have originated. However, we actually see traces of the doctrine that can be observed in African historical roots, where traditional leaders would essentially be expected to consult with an advisory body or the public, seeking approval from the population at large. And it can be seen from the following concepts. So it's different for the different tribes or the different language speakers. We've got Khotla in Setswana, we've got Pitso in Sepedi and Sesotho, and we've got Imbizo in isiZulu. So these are basically public assemblies constituted to discuss major issues affecting the community. And this essentially means that one person would not just, for example, make a decision and that would affect the entire community, or that would have a bearing on how the community conducts itself. Essentially, they would have to consult with others, and basically that's a check and balance to ensure that where matters affect people, there's a consultative process that has been undertaken to ensure that rights are protected. And then we've got a modern conception as well of the separation of powers, which was devised by the French theorist, yeah, I do not know how you pronounce that, so you'll forgive me, Montesquieu, and first included in the US Constitution. And basically that is centered around the separation of powers being associated with the protection of rights and freedoms in the Bill of Rights. And there's a prevention of abuse from extra constitutional conduct. And that essentially means that you are not acting outside of the Constitution, or you are not acting outside of the authority that the Constitution actually provides you with. So that's a bit about the history of the separation of powers. And then the separation of powers, colleagues, is based on 4 pillars. So these are the pillars that actually bring the separation of powers to life, and they make it work. If you don't have these pillars, then the separation of powers is meaningless. It wouldn't work, and it wouldn't be effective to implement in government. So we've got the principle of trias politica, and this is the actual division. So this is actually saying that we've got now these 3 branches of government. You are dividing them clearly so that it can be seen that here is the legislature, here is the judiciary, here is the executive. It's that clear distinction between the branches of government. So that is known as the principle of trias politica. Trias meaning 3, so it basically means it's divided into 3. And then we've got a separation of functions. So it doesn't help having a division of government, but you are not separating the functions, or you're not giving a specific branch responsibility or a portfolio or authority over certain matters. So it doesn't help saying that we've got 3 branches of government, but we see that the judiciary is, for example, interfering in the executive portfolio and how it conducts itself. You do have checks and balances, but there needs to be a separation of functions so that we know that executive deals with the implementation of the law, the judiciary is dealing with of the law, and we know that the legislature is dealing with the making of laws. So we need to have that separation of functions to clearly outline that this is what each branch of government is responsible for. And then we've got separation of personnel. So each branch must have assigned to it specific persons who are responsible for the performance of functions of that branch. So in South Africa specifically, we do have that kind of separation where, for example, your members of the executive wouldn't be members of parliament as well. But there are some countries where there's basically an overlap. So here, this pillar just speaks to having specific people who are entrusted with performing the functions that have been separated out by the trias politica. And then lastly, we've got checks and balances, and this essentially means that one branch can be held accountable by other branches to check the exercise of power by that branch. So colleagues, don't confuse this with an overlap. So this is not an interference. It's actually a protection mechanism that is put into place to ensure that all the branches of government are exercising their powers appropriately. So it's not like it's an interference or it's an involvement that is outside of authority. No, it's actually put in to protect and uphold rights and to ensure that each branch of government is doing what they need to do. And in terms of checks and balances, we'll go into a bit more detail of that when we actually deal with the legislature. But when we deal with each of the principles and when we deal with separation of powers in depth. But an example of that is when Parliament questions the executive, as I mentioned yesterday. So the executive would have to report on certain of their functions. The Parliament can ask them about any of their functions and they would have to provide answers as to what Parliament is asking. So that's an example of a check and balance that is put into place to ensure that one branch of government is actually doing what it needs to do and the other branch of government is actually checking on that. Okay, so the separation of powers in the South African context, we know that the separation of powers, it upholds it upholds and safeguards important democratic values and norms, namely accountability, responsiveness, and openness. And we've got this extract from the case of Delanga versus Smuts, which says where the presiding officer there was stating that I have no doubt that over time our courts will develop a distinctly South African model of separation of powers, one that fits the particular system of government provided for in the Constitution and that reflects a delicate balancing informed both by South Africa's history and its new dispensation, between the need on the one hand to control government by separating powers and enforcing checks and balances, and on the other to avoid diffusing power so completely that the government is unable to take timely measures in the public interest. So this is an extract from that case, and essentially what they were describing here is our unique dispensation that we have in South Africa and how the separation of powers will actually have to evolve and will have to make it unique to us so that it works for the South African landscape, the legal landscape, the political landscape. So essentially what was being said here was that the separation of powers needs to be unique and it needs to work for South Africa. Just like for other countries, they've developed a separation of powers that works for them. We have developed a separation of powers that works for us and for our specific country. So the next point there, we just say our separation of powers in South Africa is not absolute. And what we mean by that is that you still have those checks and balances. There are states that actually have an absolute separation of powers where one branch of government can absolutely not interfere with another, but we found that for South Africa that doesn't work for us. We do need the checks and balances, so ours is a unique separation of powers. And then some case law to consider, colleagues. A lot of these cases are mentioned in your tutorial letter / study guide. Please do go over them when you get a chance. I'm not going to go into them. It will take too long. And as I said, please, every time you read your cases, do read the entire case. Some of the cases are very long, but it just helps you understand different principles when you actually go through the body of the case. And even when you have to, for example, invoke a case or use a case, reference a case in your exam or wherever you are using it, it helps to actually have a bit of context around what the case is about and why the presiding officer reached the decision that they did. Okay, so this is basically a summary, colleagues, of the separation of powers. It just gives a good overview, even though we're going to be discussing each of these branches of government separately and going in depth. This just gives you an introduction and just gives you a summary of what each branch of government is responsible for. So firstly, we've got the legislature. And its primary function, colleagues, is to debate, draft, amend, and repeal laws. So that is its primary function. That is what it is responsible for doing. And it also holds the executive accountable. So I did reference that when I said that the executive can be summoned to appear before Parliament to actually answer questions on their portfolios, for example, ministers and their specific portfolios. They can do that. They can be summoned for that purpose. So the National Assembly is composed of 400 representatives, and these are called MPs, members of parliament, who represent all political parties that reach the required threshold of votes in proportion to the overall number of seats. So yes, that 400 votes would, for example, be the 100%, if you think of it in that way, or if you think of a pie, maybe. And we've got different slices there that each political party or that reaches a certain number is entitled to. Then you would have your 400 seats and you would divide it according to how the specific political parties have performed in the election. So that is how it is divided up to ensure that the political parties that have actually reached specific thresholds are able to participate in Parliament. And then at the first sitting after an election, the president is elected. So as soon as the president is elected, he no longer, well, he or she or they no longer become, or they are no longer an MP and they become a member of the executive. So that just shows you that clear division between the legislature and the executive when the president actually moves over to an executive office after an election. And then any MP may introduce legislation to be debated and passed. That is a freedom granted to members of parliament to actually suggest different pieces of legislation that they would like to be enacted, and then it goes through an entire process of debating, being drafted, and ultimately being enacted. And then in terms of the executive, the function of the executive is the implementation of legislation passed by the legislature. They also make different policies and implement and administer the law and make crucial appointments. I'm going to get into the appointments just now when we get to judiciary. But the executive basically comprises the president as the head of the executive and the head of state, as well as the deputy president, and then to assist the president, because there are so many portfolios that need to be dealt with, or departments as we would call them, then the president has the right then to appoint a cabinet of ministers. And the president has power in this regard. He has authority to actually appoint and dismiss cabinet. That's why we see all those reshuffles. When they talk about a cabinet reshuffle, they're basically talking about the powers of the president to actually hire and fire the cabinet that is supposed to assist him. But an important thing to mention in terms of the appointment and the dismissal of cabinet members is that the president cannot just do it anyhow. He cannot just abuse that power to just hire and fire. The president must remain accountable, responsive and open, and act under the principle of legality and act rationally. Otherwise, the exercise of this public power may be set aside. So the president is entitled to do that, but he still needs to act appropriately in accordance with these principles. And then executive is accountable to Parliament and must report to it regularly. Parliament may remove the executive. This has not happened in our current dispensation. but Parliament actually does have the power to remove the executive, and that is why the executive is actually accountable to Parliament, and they must answer questions when they are required to and report to Parliament regularly. Okay, and then we get to the judiciary, colleagues, and this is basically the courts. And they are tasked with interpreting and adjudicating legal disputes. They also have the power or the authority, which is very important in terms of constitutionalism, to declare invalid laws of the legislature which contravene the constitution invalid. So they have that power to declare the laws invalid, but that is where the line is drawn. They can't go further than that and actually start amending laws. What their function would be there is to just determine whether a specific law is constitutional. If it is not, then they are able to declare it invalid, then refer it back to Parliament. And yeah, so the judiciary comprises magistrates, judges, and justices in various courts. We've got different courts in South Africa. They may not intervene in the legislative process until it is completed, unless no other remedies are available and harm would be caused. The harm that would be caused would be material and irreversible. So again, we see that element of not interfering. Although they have the power to declare laws invalid, they need to wait for the parliamentary process to take its course, unless harm would be caused. Okay, then we see this case of Oriani and Brosini. The court declared rules of the National Assembly unconstitutional, as they did not allow ordinary members of parliament to introduce legislation. So we can just see the power of the courts there in declaring rules unconstitutional, in declaring laws unconstitutional. It is a very important function that the judiciary has in actually upholding our constitution. And then judges are appointed by the president, colleagues, after extensive interviews with the Judicial Services Commission. So the Judicial Services Commission plays quite an integral role in the appointment of judicial officers. Also, when they are being disciplined, the Judicial Services Commission plays a big role in that. So the president actually hears from the Judicial Services Commission when judges are being appointed, just to confirm that those people are fit and proper to hold that office. But the president makes the ultimate appointment, and then judicial officers must remain independent and impartial. This is a very, very important aspect of judicial officers and the functions of the judiciary, that it needs to remain independent, because as I mentioned before, if you don't have an independent judiciary, then there can be injustices that occur because the judiciary is being influenced by other parties. So it is very important, in order to have a constitutional dispensation and for the separation of powers, for the judiciary to actually remain independent and impartial at all times. Okay, then judges are guaranteed security of tenure, and salaries may not be reduced. This is it just furthers the point of the independence, and to ensure that the judges do remain independent, they are provided with that protection. Judges may be removed through investigation by the Judicial Services Commission. So again, we see that power of the Judicial Services Commission in the appointment and removal of judicial officers. So yeah, that is a summary of what each branch of government actually does, who it comprises of, and some of the checks and balances that they actually perform on each other. Okay, then we've got colleagues, what we call the counter-majoritarian dilemma in relation to the separation of powers, and this dilemma is actually just surrounding the powers of the judiciary, and the idea that judges are able to overturn decisions of the legislature. So many have argued that by giving the courts this power, you are actually infringing on the principle of the separation of powers. You are undermining democracy by thwarting the will of the majority through a subjective reading of abstract constitutional principles. So what they're basically saying is, for example, Parliament has taken its time to actually enact a law. We know that Parliament is representative of the people. Then here the judiciary comes along and it declares that law unconstitutional. That is you would think on just looking at it primarily, or just prima facie, that is actually infringing on the principle of the separation of powers, and you'd actually think that, well, if people voted Parliament into office, then what rights do the judges actually have to declare laws that have been passed by Parliament unconstitutional? So on the face of it, it actually looks as if it's undemocratic, but we do have safeguards in the Constitution that actually address this dilemma, and that would ensure that it would actually be fair. And we've got Section 1772 of the Constitution, which provides that any person or organ of state with a sufficient interest may appeal or apply directly to the Constitutional Court to confirm or vary an order of constitutional invalidity by a court in terms of this subsection. So that is just a safeguard that is put into place to ensure that courts are not just declaring laws unconstitutional left, right, and center. The Constitutional Court would actually give consideration to that and confirm whether that law is unconstitutional or not. And then a further safeguard, colleagues, is that courts can only declare invalidity. Then they have to refer the law back to Parliament to amend. They cannot rewrite the law, thereby not infringing on the separation of powers. So the courts do not have powers over and above declaring the law invalid. That is where the line stops with them. They basically declare the law unconstitutional, then it has to go back to, well, it has to be confirmed by the Constitutional Court, and then it has to be referred back to Parliament. If the Constitutional Court agrees, it has to be referred back to Parliament, and then Parliament would either repeal the law if the entire law is unconstitutional, or if it's a specific section, then that section would be amended or it would be removed. So Parliament still has the power basically to draft that legislation, to repeal it, and to include content that would actually be in line with the Constitution. So those are the safeguards that are put into place. There are more safeguards, but these two in particular actually demonstrate that there wouldn't be an infringement of the separation of powers in particular. Okay, and then we get to the rule of law as a principle. Okay, defining the rule of law. Okay, colleagues, there's a lot of uncertainty regarding this term and how you actually define it. It's very evasive depending on who you are talking to and how they define it in the context of the country that they are living in, or in the context of certain principles. But what we do know about the rule of law is that it is independent and it is an enforceable principle. In particular, it is mentioned in our Constitution. But I'll get to that. But yeah, just remember that there's no one definition of the rule of law. It can be defined in different ways, but it embodies certain principles. Okay, so Albert Dicey in 1885 basically conceptualized this rule of law by giving it specific characteristics or specific aspects that one would consider. And the first of these is that since the law is supreme, public power can only be exercised in terms of authority conferred by law, and no one may exercise public power arbitrarily. Everyone is equal before the law. The law must be applied equally to all persons, emphasis on all persons, irrespective of their status, and all must be subject to the jurisdiction of the ordinary courts. The ordinary courts are responsible for enforcing laws in a manner that protects the basic rights of all, so that these laws function as a constitution. So what we see here with how Albert Dicey conceptualized the rule of law is that no one is above the law, essentially, is how you can capture it. The law is supreme. Everyone has to comply with it. Everyone is equal before the law, and it must be applied equally to all persons. Whether it's a government official, whether it's the man on the street, whether it's a professor of anything, the law has to be applied equally to all people. And this also speaks to the principle of equality, which is guaranteed in our Constitution. So we saw a reformulation of the rule of law in 1964, which was conceptualized by Anthony Matthews. And what he essentially said is that in a decent society, the idea that the state should wield arbitrary power over the individual is unthinkable. All persons, including government officials, are equally responsible to the law. Effective judicial remedies afford the individual greater protection than constitutional declarations. So he expanded on the concept, and what he was basically saying is that government cannot just exercise the law and they think they are above it. Everyone, including government officials, are equally responsible to the law, and people should actually be able to protect their rights by going to court and alleging that their rights have been infringed, and the courts should actually be able to adjudicate over those matters to ensure that the rights of individuals are protected. So that is just basically how this rule of law was how different people were trying to conceptualize this rule of law, but there's no fixed definition for it. When you think about it, you just essentially think about equality before the law. Okay. So the rule of law is premised on the following. Government or state must act in terms of pre-announced, clear, accessible, and general rules that are not vague and uncertain. So when you think about that, you can understand why it would make sense. Because, for example, if they told you that you need to adhere with a specific law, and you don't understand that law, it's not clear, or it has just been implemented and you didn't even know that this law exists, it would be unfair to expect you to comply with that law. So the rule of law is essentially premised on the fact that the government must act in terms of pre-announced, clear, accessible, and general rules that are not vague and uncertain, and that would uphold the rule of law. And then furthermore, rules that are created must be enforced, and disputes pertaining to such rules must be adjudicated by independent and impartial courts. So just that point again, driving it home about how courts need to be independent and impartial in order to ensure the proper functioning of our government in society, and to ensure that the Constitution is upheld. No rights of people may be determined, deprived, or limited through overly broad and arbitrary discretionary powers. So that means, for example, the president cannot just wake up and decide that there's going to be a law that is going to be implemented. It is Parliament's duty to implement laws, and the executive cannot interfere with that, or they cannot just arbitrarily decide that certain laws will be passed. That wouldn't be allowed in our current democracy or our current constitutional dispensation. Then no one is above the law. All persons, including the state. So you can see it's being emphasized, government, the state, all of them must comply with the law and must act in terms of powers granted by the law and comply with laws. So if we are to encapsulate the principle of the rule of law, a lot of people refer to it as no one being above the law, or no one is above the law, or everyone is equal before the law. When you think of the rule of law, that is what you should think of. The law applies the same to everyone, including government. No one is able to place themselves above the law. Okay. Okay, so we've in different judgments, the rule of law as a concept was dealt with, and we're just going to go over some of them. There are lots and lots of cases which deal with it, and these are just a few of them. When you do have time, you can go and look up cases in relation to the rule of law. So in Fedshaw, Life Assurance and others versus Greater Johannesburg Transitional Metropolitan Council, it was stated that the rule of law, to the extent at least that it expresses the principle of legality, is generally understood to be a fundamental principle of constitutional law. It seems central to the conception of our constitutional order that the legislature and executive in every sphere are constrained by the principle that they may exercise no power and perform no function beyond what is conferred upon them by law. So that just links it up, the interplay between the rule of law and the principle of legality, that no one can actually exercise power greater than what has been conferred upon them. So it's a nice linking there with the administrative law principle of legality. And then we've got economic freedom fighters versus Speaker of the National Assembly, and others, where it was stated that the rule of law obliges an organ of state to use the correct legal process. For a public official to ignore irregular administrative action on the basis that it is a nullity amounts to self-help, and it invites a vortex of uncertainty, unpredictability, and irrationality. And they went on to say that our foundational value of the rule of law demands of us as a law-abiding people to obey the decisions made by those clothed with the legal authority to make them, or else approach the court of law to set them aside so that we may validly escape their binding force. So this again just speaks to public officials and how they exercise their power. They have to be subject to law. They cannot act outside of their powers. Otherwise, this creates a lot of uncertainty and unpredictability, and it can even go further and infringe on rights. Okay, and then we've got the case of Lisabo versus Northwest Agricultural Bank and another. In this case, it was stated that using public power to dispose of a debtor's property without recourse to a court constitutes self-help, which is inimical to the rule of law. So self-help, what that term means is actually taking the law into your own hands, which we know in South Africa is not permitted, well, save for situations, for example, like self-defense and that, but to a large extent, we always have to defer to the law, and we cannot act on the basis of self-help, where we take the law into our own hands and we do what we want to do. So they're basically saying that taking the law into your own hands is basically an enemy of the rule of law, and it would actually infringe on that principle of the rule of law to take the law into one's own hands. And they went on to say that the respect for the rule of law is crucial for a defensible and sustainable democracy. And what that means is that in order to actually exercise our democracy, the rule of law needs to be present and it actually needs to be effective. So those are just some of the case law that you can have a look at in terms of the rule of law. And then we move on to the last concept, which is important for constitutional law, which is democracy. Okay, another term that is very difficult to define is democracy, because depending on who you are talking to, they will define it differently in terms of what it means to them. But it's interesting that the term democracy is actually commonly used in conjunction with concepts such as liberal, constitutional, or majoritarian. It doesn't, the concept of democracy is not a synonym for these concepts, but it is always spoken of in relation to these concepts just because of what democracy means and what democracy encapsulates. And what we know is that democracy, like the rule of law, is an independent concept that can be enforceable in its own right. And if we do try and define it, which we can't, but if we do try and define it, it's based on the idea that the will of the people should prevail and people should have a say in how they are governed. So when you look at the Freedom Charter that we spoke about yesterday, allowing the people to govern, it's just about enabling the inhabitants of a specific country to actually participate in how they are governed, in how government operates, and giving people that voice. It can be done in different ways, but essentially what it is premised on is allowing the public to participate in matters that pertain to their government and how they are governed. So when you think of democracy, that is basically the idea that you should think about, even though there's no fixed definition. Okay, and then the foundational reason for democracy is to enable members of a political community to act together, taking decisions collectively in matters that affect them. And you can understand why democracy is such an important thing and why it must exist, because imagine someone making decisions that affect you and you are not involved in that decision making about matters that affect you or that affect your community. It would be unfair for laws to just be passed or for changes to be made that affect you and you actually don't have a say in any of that. So that is the principle of democracy and why it must exist, and why it is an independent and enforceable principle which is central to constitutional law. Okay, so democracy in the Constitution, we see in section 1D of the Constitution, it stipulates that the Republic of South Africa is one sovereign democratic state founded on the following values. So I've just omitted A to C there because I wanted to focus on subsection D, where it talks about universal adult suffrage, a national common voters roll, regular elections, and a multi-party system of democratic government to ensure accountability, responsiveness, and openness. So we can see here that democracy, or the principle of a democratic government, is actually a pillar of the Constitution. It is a pillar of our current constitutional dispensation, and the reason for that also in terms of our South African Constitution is that before the current Constitution was enacted and during apartheid, that wasn't a democratic state. So there is this emphasis on democracy because it is one of the areas that we were trying to remedy with this Constitution, and that is why it is so important as a pillar of the current Constitution. Okay, and then we see in section 19(1) of the Constitution, that forms part of the Bill of Rights. It says every citizen is free to make political choices. And that includes voting, that includes creating a political party, that includes participating in any political party. That right is actually guaranteed in terms of the Constitution, and it shows how democracy is actually put into play in the Bill of Rights and in the Constitution. Okay, although not explicitly specified in the Constitution, Section 1D embodies indicative elements of democracy in a society, being the following. So what that essentially means is that when we are trying to identify a democratic state, these are kind of the pointers or the elements that we would look at to determine whether a country is a democracy or not. Not all countries are a democracy, but South Africa is, so this is what South Africa actually has. And that is a government based on consent of the governed through free and fair elections, the active participation of the people as citizens in politics and civic life, protection of the human rights of all citizens, respect for the rule of law, majority rule, and respect for minority rights, constitutional limits of government, which goes back to the principle of the separation of powers. yeah, so these are the elements that we would look at to determine whether a country is a democracy or not. And then we've got 5 different types of democracy. There's not just one. And interestingly, South Africa actually applies all of these in one way or another. We actually have all of these different types of democracy being implemented in South Africa. So we've got a direct democracy, representative democracy, multi-party democracy, participatory democracy, and direct democracy. Those are the 5 different types of democracies. Okay, so just going into a bit of an explanation in terms of the different types of democracies. As I mentioned, South Africa has all of these present actually on our political landscape, which we should actually be very grateful for. Because it means they really enable people to have a voice in how the country is governed. Okay, so the first one is direct democracy, and what this essentially means is that people have a direct say and direct participation on the part of citizenry rather than through elected representatives in the decision-making of their political community. So what this would entail is an individual vote by citizens on every piece of legislation. So we know that that is not what actually happens. We actually elect people to do that, but there would be certain instances where direct democracy would be exercised. But because of the nature of our country, how big it is, how complex our government is, it would not be practical to enable each and every citizen to vote on each and every piece of legislation. Otherwise, we would never get anything done. We would never get any laws implemented. But there are times when direct democracy would be implemented. Okay, I see there is a question. I don't know if that's a question or a comment. Let's see. Patrick, do you have a question or a comment?
Yeah, hello. I just needed, ma'am, for you to consider just to rectify on those 5 democracies. Something is wrong there. You must check you do have direct democracy twice, but you do not have constitutional democracy. So I wanted us to be.
Oh, okay. Where is that on the previous slide?
On your slide. It's not yourself. It's the slide. You correct the slide.
Okay. All right. No, I'll have a look. I'll have a look at that and I'll correct it. Thank you so much.
Okay.
Okay. Yeah. So direct. Thanks. Oh, sorry. Were you still talking, Patrick? No. Okay.
Just for us to come aboard so that we mustn't make a mistake.
Okay. No, thank you so much for that. I'll fix that. I didn't see that was an error. Okay. So where we do see that direct democracy actually finds application, this is section 17, which also forms part of the Bill of Rights, where it says that everyone has the right peacefully and unarmed to assemble, to demonstrate, to picket, and to present petitions. So that is a right that is actually guaranteed in the Bill of Rights for all persons or all inhabitants of South Africa. And then we've also got section 84.2, which deals with the executive, and this one entitles the president to call a national referendum in terms of an act of parliament, meaning the views of citizens can be called on or certain issues can be voted on through a direct ballot. So it's not done very often, this referendum process, but it would call on the public to basically vote on specific issues, and that would be an exercise of direct democracy. Okay, then we go to the Merafong Demarcation Forum versus President of South Africa case. This was a typical example of how direct democracy was exercised. And what happened in this case, colleagues, was that there was a community which was given an opportunity to basically participate in discussions regarding relocating that specific community from Gauteng to Northwest. So they involved them in discussions on whether this specific community should be moved from one province to another. And 74% of the inhabitants of that community were actually opposed to this community being moved, but it was still implemented. So they still moved this community from Gauteng to the Northwest, and the people were very unhappy. There was widespread protests. There was violence, but the Constitutional Court still held that there was adequate participation, because they still consulted with them, even though they did not take their recommendations into, well, they didn't implement the recommendations of the community. They still allowed them to participate, so it was sufficient for those purposes, and the relocation of that community was actually valid. Yeah, so that is a typical example of when direct democracy can come into play. It works well for smaller communities, because then you can actually get every single person to vote on a specific issue or to have a say on specific issues, but it doesn't work for a large population. Okay, then the next one is representative democracy. And what this entails, colleagues, is political parties assuming a preeminent role in governance as elected by the public. So that means you and I, as citizens or citizens of the country, would be entitled to elect specific people or a specific political party to actually represent us. And when we elect those people, then we're basically giving them the authority to enact certain laws, to act in government, and to perform certain functions. So as we know, in South Africa, every 5 years we have our elections where we get the opportunity to elect representatives who can act on our behalf. And we only hope that they act in our interests. They don't always do, but we do vote for the party that we see as being affiliated to our interests, so that they can represent our interests in government. And what we have in South Africa is a closed list proportional representation system. So what that means is that prior to elections, political parties will basically have conferences where they formulate a list of MPs that will represent that specific political party in parliament. And anyone should be able to, well, anyone having an interest should actually be able to see who is being put forward as an MP, because obviously they are representing your interests as a citizen, and they are going to have a say in parliament as to what laws are being implemented. So that is what a representative democracy is. It's where you elect someone to represent you and to act on your behalf. And it is largely what we have in South Africa. We have representatives in the form of political parties, sometimes in the form of individual persons who are able to represent our interests in parliament or in government at large. Okay, so some cases relating to representative democracy, colleagues. I'm not going to go in depth with these cases. You can go and have a read through them. In the Richter case, it was held that the right to vote is a crucial working part of democracy. So they were just entrenching that principle that to be able to have free and fair elections, to be able to vote, is actually central to one exercising their democracy. And it's what I keep telling you, that in order to exercise your democracy, you actually need to vote. That is how you have a say in how you are governed. And then in the My Vote case, there the court held that the legislature is obliged to enact legislation regulating regulating the reporting and publicizing of political party funding. So this actually ultimately resulted in legislation being passed in this regard, and now political parties actually have to disclose who is funding them. I mean, it's just part of the transparency surrounding political parties and the people that we are voting into place. We want to know if they are being influenced. We want to know the sources of this funding so that we know how the political party is being run. And then in the DeLille case, Patricia DeLille, when she was still a member of PAC and a member of Parliament, she was suspended actually from Parliament for saying, well, for her certain utterances that she made regarding some members of Parliament being apartheid spies, and she withdrew her statement, but she was still suspended. She was still suspended by the Speaker of the National Assembly because of those comments that she had made. And in this case, the court actually held that by suspending her, she was unable to represent the members of the PAC who had voted her into that position to represent them, and therefore it was unconstitutional to actually suspend her. You can actually go and read that case, very interesting case, in respect of just representation and how important it is for purposes of democracy. Okay, the next one is a multi-party democracy. That also encapsulates the type of democracy that we have in South Africa. There's not just a single party or any other formulation. So, for example, in the United States, you've got your Democrats and your Republicans. That is not the case in South Africa. Anyone, even as you are sitting there, you can start your own political party. There's no limit on the number of political parties that are there, even though they don't all go to Parliament, but everyone is free to actually create their own political party. And they can lobby, they can lobby members, you can get people to join your political party, and this upholds the principle of a multi-party democracy, meaning that there can be more than one political party that actually exists in the country. And then, so we see this case of UDM versus President of South Africa. You can also go and read that case if you have time. And in that case, it was basically stated that a multi-party democracy contemplates a political order in which it is permissible, for different political groups to organize, promote their views through public debate, and participate in free and fair. These activities must be subjected to reasonable regulation compatible with an open and democratic society. So yeah, in that case, they were just basically entrenching the idea that anyone can form a political party. South Africa is based on a multi-party system, and any political party should actually be entitled to participate, provided they have met all the requirements, of course, for the establishment of a political party and to participate in elections. And any law which basically goes beyond saying that a multi-party democracy is actually available will be invalid. So anyone who tries to limit the creation of a political party or a political party from participating, that anything of that sort would actually be invalid in South Africa. You do have the right to actually participate. Okay, then we've got a participatory democracy, and what this means is that whenever decisions are made regarding the amendment or introduction of new legislation occurs, the people must be given an opportunity to meaningfully participate in the process, failing which the legislation would be declared invalid for failure to comply with the procedural aspects of the Constitution. So what we're seeing here is an interplay between representative democracy and participatory democracy, how those concepts of democracy actually align with each other. So participatory democracy actually enhances your representative democracy, and it just ensures that people are able to participate in a meaningful way. The key word there is meaningful. So it doesn't help for people to just be able to participate. They actually need to participate in a meaningful way in the democracy, and they shouldn't be totally excluded from decision making. So as much as you do vote political parties into power, it shouldn't completely take away your voice as an inhabitant of South Africa, as a citizen, to actually have a say in what is happening in government, even though you have voted people to represent you in parliament. And where we see a manifestation of this, colleagues, is in section 59 and section 72. So these sections actually say the exact same thing. It's just that on the one level, section 59 is talking about the National Assembly, whereas section 72 is talking about the National Council of Provinces, the NCOP, which is the second house under the legislature. So the sections say that there should be a facilitation of public involvement in the legislative process and other processes of the assembly and its committees. So that's just saying that the public should actually be given an opportunity to provide comments. That's why when they publish a bill, for example, they publish it for public comment, so that whoever wants to have a say, they can actually give comments on that legislation. And we often find that, for example, your experts on different laws will actually give comments and say that this doesn't work in this bill, this doesn't work, this would infringe on this right. So that's part of actually involving the public in giving comments on specific legislation, and that is very important to ensure that the public can actually participate. So we've got two of these cases. So I think the one case is the case that one of our colleagues was asking about in the beginning. And it's related to participatory democracy, as I had mentioned. So in this Doctors for Life versus Speaker of National Assembly case, you can go and read that as well. I'm not going to do an in-depth analysis of the case, but in this case, they discussed this principle of participatory democracy, and they said that it is very important. It is very important in a country like ours for disempowered people, where great disparities exist, and there's a huge gap between the poor and the rich. It is very important to have a democracy that is actually participatory. And they also said in that case that representative and participatory democracy are mutually supportive and not in tension with each other. So it's what I was explaining, that you can have representatives, but it doesn't completely take away your voice as an individual, and we've seen that in those sections. And then in this City of Tshwane case, yeah, I think that is the one where it was discussing the renaming of Pretoria, the Pretoria municipality, to Tshwane, and there they were actually just talking about the principle of having people participate and having a say in what affects them, because you know, the Pretoria name was given before democracy, and it had its own connotations, and the introduction of this Tshwane name for the municipality, it had a meaning for the inhabitants of that municipality. So this case was just basically talking about enabling people to participate in actually the renaming of the municipality. And then the last one is constitutional democracy. So this just basically relates to the idea that political decisions are made in terms of a constitution. All law and all conduct must be compatible with the constitution, and if it is not, it must be declared invalid. Constitutional democracy is confirmed in the constitution through the following elements. What I do just want to say is that the constitutional democracy is very closely linked to constitutional supremacy, and that's why you can see some of the elements of constitutional supremacy being included in the discussion around constitutional democracy. And it's just making the constitution a central part of democracy and ensuring that any and all laws, any type of participation should be subject to the constitution as a supreme law. So some of these elements include a supreme justiciable constitution. That just means that people need to be able to bring disputes in relation to the constitution before the courts. A culture of human rights, commitment to a broad range of democratic ideals, non-racialism, multiculturalism, and multilingualism, which we all know are central to the Bill of Rights and central to the Constitution and our society. So that is a constitutional democracy. It basically just places the Constitution at the center of everything, ensuring that democratic participation is actually done in accordance with the Constitution. Okay, colleagues, so that brings us to the end of our very long tutorial. It took a bit longer than I expected today. But yeah, so those are the 4 concepts that you need to understand in order to understand constitutional law, because these are concepts that will be used time and again, even as we go forward with the other topics. So it's important for you to understand these concepts, understand how they operate and how they feature and how they interplay with the Constitution in order for you to actually understand constitutional law. As I mentioned, the separation of powers is going to be dealt with on its own, so we're going to delve deeper into some of the intricacies that are related to the separation of powers, and that will be done in our next tutorial. So in terms of our class activity today, we are a bit out of time, but if you can answer these questions for me, if I do have volunteers who would be able to answer these questions. Otherwise, if no one is answering the questions, we can just maybe deal with some of the questions that you have regarding the content of today's tutorial. But yeah, otherwise, let's jump straight into the class activity. The first question I have to check your knowledge is which type of constitutionalism describes South Africa's current democratic dispensation? Oh, I've got a hand. I don't know if that's an answer already. That would be very impressive. Let's see. Josiah.
I'm sorry, ma'am. It's not an answer. You're cutting me off guard.
Okay.
Yeah, I just wanted
okay,
to.
Cool, no problem.
Yeah, I wanted to say I just joined this by default because I'm not even aware that there is a class. I don't know who you are, those kind of things. I thought maybe if you could just shed light so that you put us. I don't know whether I don't know. I must just be honest. And I'm sorry for that. I'm so sorry for that.
No, not a problem at all. Not a problem at all. You should ask. Imagine a stranger just coming to tell you about constitutional law and you don't know where they're coming from. Okay, so I did introduce myself yesterday in the first tutorial, and Godfrey, who's the tutorial officer, also did introduce me in both yesterday's session and today's session. My name is Esther Kasambara. I am a tutor. So I'm not a lecturer. Please don't think I'm a lecturer. I'm just tutoring. And I'm basically assisting Professor Stone with tutoring this subject just to help facilitate your understanding. So this is not a replacement for your lecture. Your lectures are still every Tuesday between 2 and 4, and that is with the primary lecturer, who is Professor Lee Stone. So her classes are still every Tuesday between 2 and 4. I'm just a tutor. There are other tutors available as well. I'm just a tutor who's assisting you with the course material to understand constitutional law, and my sessions are on Mondays and Tuesdays from 6 to 8. So yeah, that's who I am.
Thank you very much for that.
Sure. Okay, I see I've got another hand. Let's see. Nogukanya, I see you've got your hand up. Do you want to answer, ask a question, make a comment?
I'd like to get clarity.
Yes.
Since you are tutoring every Monday and Tuesday and it's 6 to 8, right? Right after professional sessions, do you touch on the same details? Do you polish on the same details that you previously touched on?
Sure. Okay, I lost you at the end there. Didn't hear the last part that you said. Do I touch on what?
On the same details, on the same work that you also worked on the very same day.
As the lecturer?
Yes.
Oh, yes. So I have spoken to the lecturer and I gave her my schedule for how I would like to tutor the module. And she was fine with it. But the issue is that we won't always be doing things at the same pace. For example, I know today that she was covering chapter 2 as well, so she did deal with a lot of what I've dealt with in today's tutorial, maybe with not so much detail, but I know she did do chapter 2, so I will try my best to ensure that we sort of align, so that when you're coming from the class, then you come straight into the tutorial and you're hearing the same thing, but it won't always happen because we're working on different schedules. So I don't want you to get confused. It won't always be the same, but where it is possible, I will try and cover what she's covering in that specific class. But also it is a bit of an issue because I mean she only presents the class between 2 and 4 and I do my preparations like 2 or 3 days before, so it won't always sort of align, if that makes sense. It won't always align, but for today I do know that it aligned because she covered chapter 2 as well.
All right, thank you so much.
All right, thank you. There's another hand. Let's see. Ndlovu, you've got your hand up.
Okay, I wanna answer.
Yeah. Oh, I love an answer. Which one are you answering?
The first one.
Yes.
It's under the constitutionalism understood on prescriptively. Yeah, understood prescriptively.
Yes. And what does that mean? Can you tell me what do we mean by a prescriptive constitutionalism?
It's the one that deals with identifying and prescribing the norms and values.
Yes, 100%. 100%. Love it. Yes, you're 100% correct. So in South Africa, we've got the prescriptive type of constitutionalism, and that means that we don't just have a constitution that describes the separation of powers or that describes the law. We actually look at certain norms and values and principles, and that just makes us different. So we in the current dispensation, we are actually living in a prescriptive constitutionalism. That is 100% correct. Okay, I see there are other. There are so many hands up. I don't know who's first. Let me check. Okay, no, some hands have gone down. Okay, I see Patrick. No, sorry, not Patrick.
Yes.
No, Patrick, sorry, someone's hand was up before yours. Sorry, I just want to go in the order. I'm just trying to see who was number.
Oh, you will.
Fellow. Apologies, I'll come back to you, Patrick. Kulufelo, your hand is up.
Yes, evening. I was wondering if it's possible, can we also have the slides? I think they were very well summarized on the slides. Can we also have them if it's possible?
Hey, but when you want my intellectual property, this is my intellectual property.
I wasn't aware that it's yours. I was not aware of that. But
no, I
think
did. I did prepare them, and I prepared them based basically on your tutorial letter 102. So I will make them available to Godfrey, and then he will send them over to you.
I will definitely appreciate that because I felt like they were fruitful. I haven't been attending the sessions, but
Yeah.
with today, I've already learned so much. So I'm really grateful for that.
Okay, all right, not a problem. No, I'll make them available to Godfrey and then he'll distribute them to you. Not a problem.
Thank you.
All right. And then there was witness. Witness was number 2, and then Patrick number 3. Witness. Would you like to say something? Answer a question. Answer a question. Ask a question. Make a comment.
I just wanted to answer question number 2. That yeah, the 5 democracies that we have in South Africa.
Yes.
Which is the representative democracy, the direct democracy, participatory democracy, multi-party democracy, and the last one is constitutional democracy.
Thank you. Yes, that's 100%. And I guess you got it right because you were paying attention to the slides because I had made a mistake. Yeah, thank you. Thank you for that. Okay, yes, that is 100% correct. Those are the 5 different types of democracy. And as we said, all of them are actually demonstrated in South Africa. We are very fortunate to actually see all the different types of democracy at play, even though some are more than others. But yeah, it gives us reassurance that we are actually living in a democratic state. Okay, moving on to question number 3. If we can sum up the rule of law in a single phrase, what would it be? What would that phrase be? What is the first thing that comes to your mind when you think about the rule of law? Let me see. Tandega, I see your hand went up first.
Hi.
Hi.
To me, when you talk about the rule of law, it just basically means that no one is above the law. Yeah, that's the phrase that just comes to mind. That no one is above the law.
Sorry, I missed you there, Tandega. What did you say?
I'm saying, to me, the phrase that comes to mind is just that no one is above the law.
Yes.
Yeah.
Yes. 100%. Yeah, that is a phrase that can be used to sum up the rule of law. That is 100% correct. No one is above the law, not even government. Correct. In Ndlovu, I see your hand is also up. Do you want to say something different?
No, she said it, but then I can also say everyone is equal before the law.
Yes. Everyone is equal before the law. No one is above the law. Yes, that's 100% what the rule of law is trying to encapsulate. Let's see. Let's see whose hand was up next. Jessica. Jessica, I see your hand is up.
Good evening, ma'am. I just wanted to find out, you have not made mention of the prescribed textbook, only of the tutorial. What I wanted to find out is it necessary for us to actually read the 8 chapters word for word, or can we skim through it? I'm just trying to understand where the textbook. I know it's very important for the exam, and we have to reference it and stuff. I just wanted to know: do we have to read every chapter word for word?
Not necessarily. Not necessarily. You do need to read your textbook, but just remember that the lecturer has actually developed that tutorial letter 102, which is basically a nice summary of the textbook. It breaks down the concepts in a way that you can understand. So I would say that tutorial letter 102 will, it should be your reference material, right? And then you will read the textbook in conjunction with that, because it basically just takes what is in the textbook and it breaks it down in a way that you can understand, because the textbook is quite big, and some of the things are difficult to read. That's why they did that tutorial later. So I would say still read it. You don't need to read it word for word, as long as you can understand all the different principles that are included in that tutorial later, then that is sufficient.
Okay. All right. Thank you, ma'am.
All right. But still read it, right? Still read it.
Okay. All right.
All right. Hold hand. Okay. Yeah. So for purposes of next week's tutorial, colleagues, I would just like you to prepare a brief 10-minute lesson on the separation of powers, which will be presented to the class. Can we have any volunteers of who is going to present a brief lesson for us? It will just be in the beginning, just to give us a feel of the separation of powers. One of the students will actually present that, just to give you an opportunity to tell us what you understand by the separation of powers and all its different elements. Do we have any volunteers? No, no one likes homework. No one likes homework. Okay, anyway, if we don't have volunteers, then any of you can just prepare a lesson. I'll ask next week if any of you have done it. And if you have, then we can maybe just hear from the person who's prepared a lesson on what they understand by the separation of powers doctrine. Please limit it to a South African context. That will be very nice for us to just. Okay, and then are there any other questions, colleagues? Any other questions on the material? I'll stay on the line. If you don't have questions, you can drop off the call.